The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Okay, all persons having any manner of business before the Honorable United States Court of Appeals for the Fourth Circuit are admonished to draw nigh with their attention to the court of now sitting. God save the United States and the Honorable Court.
Right. Well, we are very happy to be here for argument in person with you today. And we will hear argument first in number 21-1168, Sony Music versus Cox Communications. And Mr. Rosencrantz, whenever you're ready.
Thank you, Your Honor. Please report. Your Honor, all Cox does is provide an internet connection to subscribers. We don't encourage subscribers to download music illegally. We don't make the technical work. We did not create the software, the websites, or the servers that are necessary to commit infringement. And it is undisputed that we cannot block or monitor or in any way police the infringement that goes on in our infrastructure or any other bad conduct that occurs on the internet for that matter. No notion of tort law or copyright law ever conceived would authorize liability for an act that is this far removed and this uninvolved in the unlawful conduct, especially for the tens of thousands of subscribers with only 2 or 3 accusations of infringement. And that is why the judgment that is before this court now I feel is unprecedented in every way, from the massive astronomical size to its boundless legal theories to the staggering implications of a legal rule that requires internet providers to implement mass evictions from the internet upon receipt of just a couple or 3 accusations of infringement. Now, there are any number of ways to invalidate this judgment. I'd like to spend my time today with court permits focusing on one element of each of the liability claims, the direct financial benefit element of vicarious liability, and the frankly stunning grant of summary judgment on knowledge for tens of thousands of individual claims of knowledge. And if the time permits, it'll be really important for me to get to one of the legal rulings that was responsible for multiplying the damages for award by 4. To start with vicarious liability, plaintiffs failed to prove that Cox directly benefited from the infringement. Again, we charge a flat fee. We make the same amount regardless of whether our subscriber uses the internet to download music illegally or to watch cat videos. If the subscriber saves 99 cents on a download, we don't get a cent cut. Every court to address this contest, and there are dozens, agrees that the general rule is that collecting a flat fee for a service is not a direct financial benefit from the infringement.
Counsel, can I just ask you just a procedural question? You're not challenging the jury instructions in this case, right?
That is correct.
So you are content with the judge's instruction on the direct financial benefit?
That is correct, Your Honor. We're challenging the legal theory on which the judge found the evidence sufficient. And on that legal theory, plaintiffs are urging this court to break from the consensus view and hold that it is enough to prove that we make money from the infringers simply by not terminating them when we learn that the infringement.
But what if the jury thought there was direct financial benefit for some other reason? I understand that the district court approved it for that reason, but there was no specific instruction to the jury on this. So maybe the jury thought the evidence that Cox makes more in fees when people are using these peer-to-peer networks, and I'm sorry, I don't know the technological terms, but they take up more bandwidth or whatever, and so the fees are higher. Maybe that's what the jury thought.
Well, so Your Honor, let me go directly to that. And that would be an argument about draw, that the higher bandwidth is what drew infringers to the, what I should say, the infringement is what drew the infringers to want to collect more money. It's what drew the infringers to pay more money for a higher bandwidth. The problem with that is that it is a classic correlation causation fallacy. The evidence was that the people who infringed the most, the ones who were at the very, very top of the infringement pyramid, were more likely to have purchased internet with a higher speed. Now, there are so many explanations for that. The most common sense one being that people who live their lives online are also people who are going to infringe more. There is nothing in the record that suggests that a single one of these people had faster internet because they wanted to download infringing songs. And plaintiff's experts admitted this, just like he admitted that he had no idea why anyone buys internet service. He said, quote, "There are many high-tier subscribers that don't infringe." That's 6.3. And he admitted, quote, "I don't know why anyone chose to purchase higher-tier service. Subscribers buy fast service for all sorts of reasons, most notably lawful streaming like Netflix, or because their households have so many internet users. There is no evidence and no reason to believe that when you stop a subscriber from infringing, they're going to cancel their high-speed service." And then just turning back to the theory that the district court adopted, the district court adopted this theory that we made more money simply because we did not terminate.
Well, let me ask you this question. It seems like the appellees are suggesting that the revenues from the high-speed accounts demonstrate a draw. But doesn't that go to Cox's motivation and not the customers?
The conscious motivation and not to overrun?
The higher revenues demonstrated, they say it demonstrates a draw, but doesn't that go to Cox's motivation and not the customers?
Oh, yeah, well, so yes, Your Honor, and so is the point that I was just making. It goes to Cox's motivations and not to the customers. Whether you are talking about what gets the customer to buy internet service, or what gets the customer to buy higher speed internet service, the draw has to be what is drawing the customers, and there was no evidence. Again, the expert that I quoted earlier also said the same thing about not knowing what draws people to internet service. Now, we know what draws people to internet service. It's the fact that you cannot live a modern life without getting internet service. But there is no evidence on this record that infringement was what was drawing people to internet service or what was keeping them there. And on the high-speed point, there's no evidence that anyone canceled high-speed service upon learning, oh my goodness, I can't infringe anymore. If there are no more questions on direct financial benefit, I'd like to turn to knowledge.
Yes, and I don't mean to push you off your plan, but on contributory infringement, I guess I want you to talk about the part that went to the jury, which I guess is sort of what I think of as the conduct prong, not the knowledge prong. And I am confused because, right, again, there is no challenge to the jury instruction. So your position has to be that no jury could have found on these facts a material contribution or inducement or causation on the evidence presented at trial. And the evidence presented at trial, right, was not just that Cox did not immediately terminate, didn't, I think what you called evict from the internet after a couple of notices. There was all that other evidence, the same evidence that this court in BMG thought took Cox out of the safe harbor, all of that evidence of a sham policy, misconduct, the emails. And so I want you to have a chance to address, because I really didn't see this in the briefing, the facts of this case and why a jury couldn't infer kind of a culpable intent to encourage infringement from that evidence, not from the failure to cut off after one or two notices, but from the, the larger aggregation of evidence in this particular case.
So yes, Your Honor. So material contribution is aiding and abetting liability. There has to be a culpability with
Right.
respect to each act of infringement. So just as in PMG, there was a requirement that the knowledge element be satisfied with substantial certainty that this particular accused infringer is substantially certain to continue infringing. There also has to be culpable intent for cause, that you can infer that the intent that that person will continue infringing. You can't possibly satisfy that standard with respect to easily with respect to 3/4 of the accused subscribers here who stopped infringing by the third notice. It's got to be a subscriber.
Does that, I don't want to take the attention away from this prong that Judge Harris is interested in, but your culpability argument you seem to be talking now about knowledge, right? That you have to be able to foresee that this particular subscriber is going to infringe again.
So yes, that, Your Honor, but you also have, the plaintiffs also have to demonstrate Cox's culpable intent with respect to that subscriber. If 2/3 of the people who are accused of subscribing stop infringing after the third notice, Cox shouldn't be terminating them, and failing to terminate them cannot be culpable intent. And I see, Judge Harris, you're looking again because your earlier question was about, well, the whole course of conduct. Secondary liability has to be about what the culpable conduct was here. And we did not proximately cause the culpable conduct of the person who infringed twice and then infringed the third time.
Well, but we did say, right, in BMG that, we apply the regular rule that ordinarily people intend the consequences of their actions. And I understood the district court to be saying, look, there were simple measures that Cox could have taken here, not cutting everybody off after 2 notices, but doing something about copyright infringement. And on this evidence, this jury was entitled to find that Cox did nothing. It didn't take any simple measures to try to address the problem. And I guess I'm asking you to explain why you couldn't infer from that failure to do anything, and instead to have a sham policy and an intentional, purposeful effort not to actually employ it to address the problem, why you couldn't infer from that what we talked about in BMG, just that, that you intend the normal consequences of your failure to take a simple measure.
So Your Honor, I'll address it in 2 pieces, and I see my time is running out, so I do want the other point and to knowledge more specifically. So about the culpability point, that is what you described as the conduct point, you made 2 points. The first is simple measures. Now, the Supreme Court's standard is about affirmative steps. Simple measures is simply something that the Ninth Circuit came up with that wouldn't even apply here, because there are no simple measures other than terminating those people with 2 or 3 or 4 acts of infringement. At least nothing else that got us held liable. And then the culpability that this court assessed in BMG, that was about the top of the pyramid. It wasn't even the top, it was the top of the steeple of the pyramid. It was the tiny, tiny percentage of people who were not terminated when they got to the termination stage. But bear in mind that we are talking about conduct that is committed at the hands of only 1% of our subscribers, and only 0.05% of them are at the top of that pyramid. 95% of that 1% stop infringing before you ever get to the termination phase, which was the culpable conduct that this court observed.
Well, let me ask you, it seems to me the judge directed a verdict or directed on the specific instances, and that he didn't charge, or well, he said the second element, that Cox knew of specific instances of infringement has already been established. Why wasn't that objected to?
What was the jury instruction?
Why wasn't it objected to?
Oh, well, so Your Honor, we did object, but the judge directed a verdict based upon summary judgment. And we certainly took exception to the summary judgment. And so what the court did here was to direct a verdict on summary judgment that knowledge was satisfied. Now, knowledge is the quintessential fact question. If the district court directed a verdict, not just that we had general knowledge about bad conduct at the top of the pyramid, but we had specific knowledge as to each particular infringer. This court could not have concluded about what plaintiffs have to prove. That Cox could not be held liable for any of the infringers active in the infringement unless Cox knew that that specific infringer was substantially certain to commit the next act of infringement. BMG repeatedly emphasized that this is.
I assume I agree with you. Where in your summary judgment briefing was predicting future infringement discussed? Where was this argument raised?
Well, Your Honor, no one disputes that we raised the argument about future acts of infringement. We said over and over again, just because you have 2 acts of infringement or 3 acts of infringement does not prove that that the next act of infringement will occur. Plaintiffs argue that we did not make a past acts argument, but they're not arguing that we did not make the argument that I'm making to you today, that the past acts.
Well, just to help me, maybe you can, on reply, you can give me the JA pages. I did read your summary judgment briefing, and I think you're making a good point now, but I had trouble finding the point about predicting future conduct. That's certainly, the district court seemed to proceed as though past instances of infringement were sufficient.
So Your Honor, it's a JA 1998, I'll quote, repeat infringement cannot be imputed merely from the receipt of notices of infringement. So that's where we made that argument. I see
Thank you.
Time is up. If the court will permit, I would, in the interest of not getting fired, I'd like to at least make one argument on the damages.
I'll give you just a minute or two.
Okay. That is
And do you guys, great, do you guys have questions? Yeah, just a minute or two.
Okay, so let me just focus on the derivative works issue. That is a $220 million legal error. There is no material dispute of fact that more than 2,200 of the sound recordings for which plaintiffs recovered were derivative musical compositions for which plaintiffs received. We documented the duplication based upon evidence that was in the trial record. The district court told plaintiffs that they had to, quote, produce sufficient evidence to contest any of them. Plaintiffs availed themselves of that opportunity as to 105 of the recordings, which we are not now contesting. But as for the vast majority, that's 94% of all of the sound recordings, plaintiffs had nothing to say. Under basic JMAL principles, then, the district court had no choice. There was only one reasonable answer to the question as to whether any of those 2,200 were entitled to a separate award. So there was no question for the jury to resolve. The district court initially agreed with us that it had all it needed on the record to conduct the analysis, but that it decided not to. It reasoned that this was not a ministerial task. But JMAL doesn't depend upon the as ministerial or required. And the protest about the effort that was irrelevant because plaintiffs' decision to sue over 10,000 works did not relieve them of the basic burdens of putting evidence in if they wanted to dispute.
What number was given to the jury by Cox for the number of works that were infringed?
Well, so Your Honor, the judge decided not to instruct the 370. And when plaintiffs.
Was there evidence put in front of the jury? I know you didn't argue because the judge rejected your jury instruction, but I guess what was the testimony or the evidence to the jury to help them make this distinction? I know they had PX1 and PX2 and the registrations, but what was the evidence to help them discern the lower number?
So, Your Honor, that was it. It was PX1 and PX2. It would take a lot of work, of course. The judge refused to allow us to put in additional calculations. But the bottom line is on JMAW, what matters is what was in the record for the jury and whether there was material dispute with that, just as there would be in summary judgment. Courts all the time decide this number of works question as a matter of law. And when plaintiffs did not put at issue, did not dispute the material fact as to 2,235 of them, the district court had no choice but to correct, but to issue a JMAW order.
Thank you.
Good afternoon, Your Honor. May I please report? Can you all hear me if I keep my phone here? My name is Kate Stetson. I represent the plaintiff copyright holders in this case. I'm going to start with just a couple observations, and then I'd like to turn to your questions to Mr. Rosencrantz. But the two overarching observations I would like to make is first, this is not a case that broke some seismic new ground. This was a case about an internet service provider that was found to have facilitated granted copyright infringement on its systems. As Judge Harris, you pointed out, this isn't about whether the provider should have terminated every subscriber upon every instance of infringement. This is about whether the provider could do something. And it certainly could do something up to and including termination. It could have suspended, it could have educated, it could have throttled down. All of these things are required. This is not a narrative about terminating every subscriber. And that's what it's turned into.
I agree. It has sort of turned into that on appeal, but I thought that was your position, that as long as an ISP has specific notice of one or two infringing acts, then it's going to be contributorily liable if it doesn't immediately terminate service. Is that not your position?
No, I think our position is broader. Our position, and the district court articulates this below as well, is the ISP needs to do something. It needs to suspend or terminate. In fact, the district court, during the proceedings, there were repeated testimony from multiple witnesses about other things that could have been done, including education, including suspension that I mentioned, including throttling down. So this is not just that single event. Second of 2 points. I think with respect to both DMG and jury, what you see in the briefing and what you've heard today is a little bit of litigation for both of these things. This court held in DMG that to satisfy the proper standard for knowledge, the ISP needed to have specific enough knowledge about specific subscribers and things to do something about it. That was the proper standard this court articulated. So to the extent that there's a backward challenge to DMG going on here, including with respect to what a repeat infringer is, which you'll remember was an issue, that's not proper. The second thing is re-litigating the jury. Judge Harris, you asked a couple different times about challenges to the jury instructions, and Mr. Rosencrantz correctly answered that those weren't the challenges that he's making. But what we heard today, in a couple different points, is challenges to the evidence. So let me start with your first question, Judge Harris, with respect to direct financial contribution. And here, to begin with, I would say direct financial contribution, and this goes to your question too, Judge Harris. The standard that Cox articulated in its own brief is, did the defendant directly profit from the infringement while doing nothing this time? So the angle of the draw to subscribers isn't, I think, the appropriate way to look at the direct financial benefit question. The bottom line question is, did this defendant, did this ISP directly benefit from infringements? And what you have in front of you with respect to the jury verdict was cite after site of examples of testimony and evidence showing that Cox was making considered decisions not to terminate because of the benefit that was flowing to it from infringers. So just to give you a
that kind of glosses over what the benefit is from, right? The benefit has to be from the infringement, not from the fact that users continue to pay the same flat fee. Would Cox have made less if those subscribers had stopped infringing but kept their internet service?
Judge Rushing, there's two responses to that. The first is, I think that reading of direct financial benefit is a little narrow. There is one Ninth Circuit decision they can use that talks about that being kind of a one-to-one correspondence, but the great majority of cases, including others from the Ninth Circuit, talk about it like the Ninth Circuit did in one of these, which is if a swap meet owner is hosting the site and facilities where people are walking in the door, paying the flat admissions fee, paying the flat parking fee, and among other things, going over to that one stall that has the copyrighted CDs, that is a direct financial benefit. So here in the record, just to link the two together for you, there are instances where the abuse team members themselves say, this is Joint Appendix 221, this customer will likely fail again, which is infringing. But let's give him one more chance. He pays $317.63. Joint Appendix 224. Here's another example of.
I understand. I guess I'm just wondering. I think you acknowledge as well. There's this general rule that most courts have accepted that if you only have, say, a flat fee in monthly payments, generally that's not sufficient for direct profiting directly from the infringement. There are ways to show it despite that, right? You can show a draw that's why subscribers were coming. You're getting customers because of the opportunity to infringe, et cetera. I'm wondering if we accept your theory, what is left of this general rule about flat fee programs?
I don't think that you need to accept a broad theory that says flat fee can by itself prove vicarious liability and prove recognition. I would say with asterisk next to that, there are cases that stand for exactly that. Mr. Rosencrantz said there aren't any. I can name two off the top of my head. Both of them were recited in the NMPA. One of them is famous music, and the other one is real songs. And in both of those, we're talking about flat fees. But to your question, I think the distinguishing characteristic here is that we are not talking about one flat fee. We are talking about evidence that was put into the record by the plaintiffs about the graduated fees that were paid, including evidence that a significant number of infringers paid those higher fees for that greater benefit. That's at pages 13 and 14 of our brief. There are multiple sites to all of the evidence that was in front of the jury. And that's why I began by saying this is in some ways a backhanded attempt to start challenging my evidence. There is evidence in front of the jury about the direct financial benefit for which the jury could have concluded that Cox was benefiting. Cox told its own abuse team that it was benefiting by retaining subscribers. Mr. Rosencrantz said at one point.
So was there evidence that, you're saying that you did prove a draw, that the jury had evidence that infringers are drawn to Cox's internet service and pay more for higher speeds for the opportunity to infringe?
Judge Rushing, I wouldn't put it just that way, although I think there is evidence from which the jury concluded that the infringer paid more, yes. Our points are two in the case. The first is this notion of draw, which is drawn from an alternative holding in Formatista, is not, we think, the driver of the direct financial benefit question. The driver should be the first holding in Formatista, which is when you host a swap meet and you charge people fees for walking in the door and fees for parking, then they can go to all the stalls, including one that has infringing stuff. That's a direct financial benefit. So this draw concept, which has been picked up, I think, by some of the Ninth Circuit cases in particular, should not overstate. So it's a little bit to Judge Boyd's question which is what perspective do you look at this from? The issue, I think, with looking at it from a subscriber perspective here relates to something Mr. Rosencrantz said. Mr. Rosencrantz said there's no evidence that any subscriber quit the internet, quit Cox because it couldn't infringe. That's because Cox never terminated. What we do have is evidence that Cox said we won't terminate this person because we benefit. And if you look at Ellison versus Roberts, which is where a lot of the draw discussion comes from, the way that Ellison phrases it is, did the ISP either retain subscribers by virtue of infringing activity or lose subscribers if it cut them off? And here we have evidence in the record of the abuse team saying, we can't cut that subscriber off or we'll lose that revenue. We think that was ample evidence for the jury to conclude that there was a direct connection.
Ms. Stetson, I'd like to hear your argument as to why you think that Cox has forfeited the contributory liability issue.
So with respect to the contributory liability issue, that's the one, there are two prongs. One that went to the jury
Yeah.
with respect to material contribution, and one that went to the judge and was resolved on summary judgment. I can discuss either of those. I don't think we have a forfeiture argument with respect to contributory liability. We certainly do have one as to the element of vicarious liability. There were arguments below that were very pointed about costs not being in a position to supervise or control its business subscribers. You can see that in a number of things that are included in JA. It's now broadened on appeal to costs can't supervise or control any subscriber. And we think that was forfeited. We have very strong arguments, of course, on merits, and we have to talk about that. The core thing that we think is forfeited is the damages challenge that Mr. Rosencrantz completed.
Council, I'm sorry, I thought you thought that, and there's a lot of different Russian dolls in this case, but that with respect to the knowing element of contributory liability, you thought there had been a forfeiture on summary judgment, that there hadn't been an argument about what was required, what kind of specific knowledge was required.
That's correct. On summary
Okay.
judgment, and this goes, I think, to the colloquy Judge Rushing had with Mr. Rosencrantz. On summary judgment, there was no argument made about what I would now describe as the precognition standard. That an ISP doesn't have the ability to forecast whether Susie's subscriber is going to download Hurricane in an infringement. That's not something that was presented in the summary judgment. Mr. Rosencrantz explained that what the other side of that coin is that an ISP can't be expected to predict whether a repeat infringer will continue to infringe. There's a couple of responses to that. The first is to remember, we are not talking here about a pool of subscribers that just infringe once or twice. Joint Appendix 323 and 1363. The first of those is a cite to the district court's explanation that the pool of subscribers at issue here are the pool of subscribers that infringe 3 or more times. The great majority of them having infringed many more times than 3. Joint Appendix 1363, I think, is the most important cite for this concept. That is Cox's prior policy. Cox's prior policy was 3 strikes and you're out. So with respect to knowledge, I think that Cox's prior policy in 2004 to 2007 or 8 was 3 infringements and you're terminated. I think it is more than fair under DMG and under its discussion of what constitutes knowledge for the district court to look at the thousands and thousands of RIAA notices in front of it, all of which specify the subscriber ID, the hashtag of the hash of the file, the date of the infringement, and swore on penalty of perjury, in addition to damages claims available under the Copyright Act, that what they were saying was true. That 3 or more times for a subscriber, Cox used to think that was plenty to terminate, and that is exactly why and how this particular subscriber class was scoped the way that it was. So there's really not an issue, and I think it is an overreach to start talking about this case as being something where a subscriber infringes and then cut off the internet. That is not how this works, both because we're talking about 3 infringements
But to have knowledge, to contribute to infringement, you have to have knowledge that infringement is happening and you contribute to it. So you're contributing to something that is going to happen in the future. I didn't see any conclusion by the district court with respect to knowledge in that sense. The district court said, well, there were past notices and that's knowledge. There was no discussion of what we're talking about, which is, aiding and abetting as your friend on the other side put it, right? Contributing to something with knowledge that you're contributing to it.
I think that actually identifies the kind of precognition standard that we're talking about. If the standard after BMG, which by the way is completely in conflict with BMG, but if the standard after BMG is internet service provider needs to know that Susie's subscriber is downloading her or is about to download her.
Well, it's not in conflict. BMG didn't purport to talk about all aspects of knowledge. It talked about what the parties are arguing in front of it, so it's a particular aspect of knowledge and what it meant in a certain sense. And the court reasoned that it's a general principle of fault-based liability that someone knows his actions will lead to a certain consequence, then he intends those results. So it's forward-looking. You know that certain results are going to come because of your actions and you do it anyway. The court talked about infringement that's substantially certain to result. It's quite a jump to say that we foreclosed the idea that knowledge means knowledge that something's going to happen as a consequence of your actions, rather than knowledge that something happened in the past and you're doing, you're contributing to it in the future.
So I think if you take that discussion that you looked at, including the discussion of the VCR rental, and you put it next to what we're talking about here, there's actually a quantum of correspondence that maps onto each other. What BMG said was, if you have a service that rents VCRs, and that service knows that someone that it is collecting rent fees from month by month is using the VCR to infringe, then you can presume that that person, that lessor has knowledge of infringement. There is no other way under the DMCA's structure.
Well, that's maybe a stretch to say the court said you can presume from one. I mean, isn't that a factual question? Like how many, the person who's leasing the VCR, like how many times do they know this person has used it illegally? Has this person made promises not to do it again? How well do they know? It's a factual question for a jury, right? About what can I know about the consequences of my actions?
If there were any genuine issues of fact about what Cox knew and when, it might have gone to the jury. I think the problem that Cox has is that the information it had in front of it was thousands of notices identifying the specificity of all of those instances of past infringement, not just once, not just twice, but 3 times and beyond. And yes, there is a circumstance at that point where it becomes incumbent on the ISP to do something. That is the standard that follows inexorably, as we said in our from the Now, with respect to damages and the time that I have, I want to talk about.
Oh, counsel, I'm sorry. Before you move on to damages, you mentioned the supervision prong of vicarious infringement. And I guess I wanted to ask you, and this also goes to the direct financial benefit prong. I understand how you get to where you are on both of these prongs, but haven't we, let me just tell you my concern and give you a chance to address it. It just seems like we've gone really far afield from kind of the origins of vicarious liability, which is supposed to stem from like a principal agent relationship, like employer-employee, where here the infringing party is infringing really for the benefit of the defendant and enjoys some kind of a principal agent relationship. And I understand that there are cases that take us a little bit away from that paradigm, but this just seems like it's in a whole different universe. I am really having trouble figuring out how this case is about vicarious infringement. I mean, the one thing that seems undisputed is that these infringers are not agents of Cox, that Cox, in fact, is unable to supervise exactly what they're doing, and that whatever they are doing, it is not for the purpose of benefiting Cox.
Judge Harris, I think just to break that into a couple of pieces. The first is that the notion that vicarious liability turns on that principal-agent relationship. That train left the station in 1963. It should be a versus agent case. That was where the court said, yes, in the past, when we talk about vicarious liability as a general relationship, but that doesn't fit with certain instances of copyright. So I think beyond that, now what we're talking about is there a circumstance where an internet service provider, which after all has been identified by Congress as being eligible for liability under copyright law, is there a circumstance where an internet service provider with the ability, the conceded ability, to control access to its platform directly financially benefits from the infringement? And that's what all of that trial evidence.
So as I understand it, your answer is, and this is fine, like, as I said, there are cases that have moved away from that paradigm, and it really doesn't matter. Once we've reached it, go as far as you want.
I not go as far as you want. I don't think you need to write a really expansive decision. I think that this falls easily in line with prior precedents, including the Netcom case from 1995, pre-DMCA, that talked about the limits of liability. Follows from A&M Records versus Napster from 2001. This is not new ground we're talking about. This is simply an application of common law principles of vicarious infringement to an entity that was able to control access to its platform and directly benefited, as the jury heard, from all of that testimony, all of the evidence that I mentioned. And again, at pages 13 and 14 are brief, but they are all sites. So let me say this about this. Mr. Rosencrantz described the act of, and I know my time is up.
We gave Mr. Rosencrantz a little extra time. So.
Mr. Rosencrantz described this damages question as, it would take a lot of work to put together Plaintiff's Exhibit 1 and Plaintiff's Exhibit 2, which were the two lists of sound recordings. Cox conceded below, and realized this, at note 10 of its post-trial submission, that it would take a lot more than that. What it took, actually, was Cox's counsel, after post-trial, going into those various lists and looking at copyright registrations and determining, among other things, whether there were overlaps that looked like overlaps, but actually pertained to different songs. So just to give you the critical sites here, this is Joint Appendix 1027. This is what Cox called Schedule 2, and this is part of its 90-page submission of Charles Congrats at post-trial. And Schedule 2 has to do with the circumstances where a song looks like it might be the same song as one that's on the music composition. No, it's not. And I point you to a couple. Joint Appendix 1029 in that same chart. 6th row, the Cars song, Let's Go. And what Cox's counsel say are, the date of first publication listed on the sound recording registration significantly predates the date of first publication listed on the music composition certificate. Next page, Joint Appendix 1030, Meatloaf. The song What About Love.
Can I ask you about what about their main argument, which is that after trial, the plaintiffs didn't dispute that, what was it, 2,235 works were in fact derivative. They say that the district court had no choice but to grant judgment on those, to take those out of the count because there was no dispute of fact based on the evidence at trial that those works were derivative. What's your response to that?
The response is our discussion after the fact of various sound recordings and compositions is really irrelevant to the question whether Cox forfeited this argument by not putting evidence in front of the jury for the jury to be able to make this determination. So what we had, remember, going into the jury trial was a statement by the judge at summary judgment saying genuine issues of material fact preclude summary judgment as to all of the other arguments except for a couple of the parts. District Court reiterated in its post-trial order, the court denied that motion for summary judgment on the score because issues of fact remain that were proper for determination of trial motion. What we heard Mr. Rosencrantz mention earlier was that those pieces of evidence were sought to essentially come in to the very last witness. An expert had not testified to it in his reports and was not do the math and come up with.
So is it, is it fair to say, I just want to make sure I understand the positions correctly. Is it fair to say maybe the parties agree and counsel for both sides can look at this evidence and make sense of it and agree that there's 2,000 something derivative works, but the jury, given the evidence in front of it, did not have the evidence and the guidance it needed to make that determination. The jury could have found 10,000 derivative or 10,000 works infringed because they didn't have guidance to make the derivative distinction.
Wait, counsel, I'm sorry, just before you move on, because I'm afraid I still don't quite understand. And I haven't seen a posture like this before, but once Sony concedes, well, once it's after the fact, it becomes undisputed. There no longer is a jury question after the fact as to 2,200 of these works. Is that right?
No, I don't think that's right.
Why not? That's okay. That's the part I'm missing.
The reason that we haven't seen this before is that there's literally no other time that this has ever been. After the fact, what Sony was confronted with was an argument from Cox that said, this is just a ministerial thing. We just compare these two charts and shazam. Turns out, of course, that's not what it was. And so what Sony was confronted with was that argument. If its response was, this isn't property, this is a fact question. But if you are going to conclude that you can somehow reach this despite it being a fact question, you are the ones that we would take particular issue.
Particular issue. So you never said that you said, we'll take issue with all of them, but we're particularly worried about this batch. Is that right?
I think that's much more accurate. We took issue with all of them because we thought it was completely inappropriate for Cox after the fact to be asking for what was quintessentially.
All right. So you are saying it is not, in fact, undisputed that 2,200 and change are derivative. You did dispute that.
I think we specifically disputed 2,200 and change. I think the gap between where Cox is coming from and where Sony is coming from is the idea that by not specifically disputing the rest, we somehow conceded the rest. After the fact, after the jury verdict, that should appear for this evidence. At the point where Cox is starting to put in factual arguments, all we needed to do and what we did was to say, these are factual questions. They should have gone to the jury. And if it was the case, by the way, that the district court at summary judgment found certain things not disputed, presumably he could have ordered partial summary judgment on those words, and he did not do that. Joint Appendix 710, I think, points out the reason this needed for the jury. This is Cox's own hospital. What he says right before the last couple of days of trial is, quote, it may shock the court, but I actually hadn't forgotten about putting on evidence with regard to this. We understand that we have the burden to put in that evidence, and the evidence never came in. What you're hearing now is an attempt to backload all that evidence in so that Cox's counsel can make the kind of judgment calls after the fact that he attempted to make post-trial, and which the district court rejected. There are no further questions.
Thank you.
First started at the beginning where this started. But notice you are right. Your briefs. Your brief on appeal talks about what we should have done. It's all about determination. Not a word about not doing enough to educate. You won't find the words educated in your brief at all. And that's because that's all that the district court found, because that's all this case was about. To do something.
Well, counsel, can I say, tell me what I'm missing. It looks to me, I agree with you, as though Sony is coming in and asking us to embrace an extremely broad theory of liability. But I don't actually understand the district court to have embraced that theory. That what the district court says is it seems to adopt some version of the simple measure standard. And then it says Cox came in and it argued we did do simple measures. We didn't terminate people, but we did lots of other things to address infringement. And then the district court says on this evidence, the jury was well within its rights to reject that as a matter of fact and find that Cox did nothing. That's how I read the district court, but am I misunderstanding something?
Excuse me, that's not how I read the district court, because something that the district court said we did not do was terminating.
I don't get that.
You asked whether a jury could conclude that we did nothing, we created a virus program from scratch that became the model for the rest of the ISPs. The council said, Stephen said that we should have educated, we should have deterred, we should have suspended. We did educate, we did deter, we did suspend 60,000 people. That's why your theory was about termination, not about the quality of all the steps up to 13 leading to termination. On direct financial benefit, again, Judge Harris, your intuition is right. This is really far afield from the origins of vicarious liability for all agents. Judge Rushing, you asked a question about evidence that cops would have made less money if subscribers stopped infringing. The answer is no. There's absolutely zero evidence. Their evidence was all about bad emails. Emails suggesting that some employees were disinclined to terminate some subscribers, that is the ones at the very top of the pyramid, because they wanted to continue collecting the money, but receiving fees as a result of not terminating service is not the same as receiving fees from the infringement. It is not money that we made because of the infringement. It doesn't prove what has to be proven, which is that we had a financial interest in making sure that the infringement continues. We know that.
Can I ask you something about that has to do with the amount of damages? The statutory damages are very, there's a lot, the jury can consider a lot of factors, right? And the jury instruction listed a number of things that could be considered in setting what the judge called an amount you find to be fair. One of the factors is profits Cox earned because of the infringement. It sounds to me like that is tied to a finding of vicarious liability, not contributory, but I wanted to get your read on that.
Yes, Your Honor. I mean, you cannot figure out what the ultimate damages amount is tied to. Some elements may have been vicarious, some elements may have been about contributing, which is one of the reasons that if this court vacates on one ground and not the other, it needs to crank through the jury instructions and see how that could affect either damages or willfulness.
Well, counsel, can I stop you there? If hypothetically, we were to reverse on one ground but not the other, does that mean we'd have to send it back for a new trial on damages?
Yes, Your Honor, absolutely. Let me give you the easiest example. This court reverses on knowledge. This court has to award a new trial on damages, and in particular on willfulness, because the district court, in directing the verdict about knowledge, essentially directed the verdict about willfulness, because it said you can find that it was willful if you find that Cox knew that the subscribers were.
What if hypothetically we reversed on vicarious infringement but not contributory infringement? Would that require a new damages trial?
For the reason that Judge Rushing was just said, that some of the elements are directly tied to vicarious liability. And just for example, I mean, there's so much discretion in there. If the jury had concluded that we had a direct financial benefit, all the more reason to award higher damages. And so it would go both to
does it matter? Did you ask for a special verdict form on damages, so that the jury would have had to allocate?
No, Your Honor.
Does that matter?
So the answer is no, and no, it doesn't matter. That is exactly what happened in the cases that this court decided, that we cited most notably.
It's okay. I mean, if it's in your briefs, I've got it.
But the Barber case, there was actually Barber and tire engineering, there were specific findings about liability, but not about damages, which was exactly why it was preserved. If I may just finish the point I was making about emails. Every business makes more money if they don't terminate or don't evict a misbehaving customer. But that doesn't mean that they are benefiting directly from this behavior. By plaintiff's logic, ISPs are liable for every transgression that occurs on the internet if they fail to terminate the bad actor upon notice. In each instance, the ISP would make more money if they don't terminate, but that doesn't give the ISP what it needs under plaintiff's theory, which is a financial interest in the. Let me just close with this. This is, by plaintiff's own concession in this argument, this case is about re-notices and terminate. That is the rule that plaintiffs are asking this court to adopt. And how this court applies traditional principles in this new context will have profound implications for the internet and connectivity going forward. Plaintiffs are seeking this draconian regime that will force ISPs to terminate an entire household, university, business, or sprawling regional services provider based upon 3 accusations of 99-cent infringements. If the ISP declines to terminate, it will be liable for a penalty of up to $1,000 for each working infringement. 2 or 3 anonymous subscribers on a regional ISP infringe, tens of thousands of families and businesses get thrown into internet diaspora. A hospital orderly downloads 3 songs, and the entire hospital gets cut off. Grandma has Junior over for a long weekend, and he downloads 3 songs, she gets kicked off. And just bear in mind, this is not just about infringement. A lot of bad things happen on the internet. Bullying, false speech, sale of illegal goods. Just notify the internet provider, and they now have to terminate, possibly upon the 3rd accusation. Affirming here will fundamentally distort the law of secondary liability. No one ever thought that they could sue Mom Bell if you gave her notice that crime syndicates were using the telephone wires. The telephone company, too could be cut off. If I may just have one more sentence.
One sentence.
Internet is no different from any of these other communications. If you break out internet for special treatment, you will end up breaking the internet. Thank you, Your Honor.
Thank you both very much. We are very sorry that we cannot come down and shake hands as would be our custom, but we very much appreciate your help today and stay safe. Jonathan R. versus Jim Justice. And Ms. Lowry, is that right? Start with you. Oh,
Good afternoon. My name is Marsha Lowry, and I am from an organization called the Child. With me today is Richard Walters from Charleston, thank you. I'm sorry, I keep getting them mixed up. Charleston, West Virginia. Sorry. I appear here today on behalf of the over 6,000 children in the West Virginia foster care system. This case directly addresses the issue of whether the federal court should abstain from exercising jurisdiction because the children have ongoing state court proceedings to review their foster care placements and case plans. These are the same kinds of proceedings mandated by federal law and the same type of proceedings that take place in other jurisdictions where abstention has been declined. The district court below abused its discretion in a number of ways. It disregarded the clear instructions of the Supreme Court in its latest abstention case in 2013, Sprint. It ignored a number of cases in other circuits, both district courts and appellate courts, that reject abstention in similar cases, asserting systemic violations in the state foster care system. Relying on pre-Sprint cases that support abstention while ignoring precedent that does not support abstention. By relying on a Middlesex analysis without first finding that this case falls into the three categories that were set out in Sprint as the only categories in which abstention is permissible. And then by relying on Moore v. Sims, a Supreme Court case that abstained in a federal case that challenged the state statute authorizing the removal of allegedly abused children from their parents. It should be noted that the Texas District Court and then the Texas Appellate Court upheld a similar challenge to what we have here to the state foster care system in Texas. The abstention doctrine in Younger has been clarified by Supreme Court in three important decisions. Initially in Middlesex in 1982, in NOPSI, New Orleans Public Service versus New Orleans in 1989, and most recently in Sprint, which was in 2013. In Sprint, the Supreme Court said that there were three and only three categories of state proceedings which justify Younger abstention. And they are.
I don't mean to interrupt, but can I ask you just a question? I do think you're right that Sprint sort of certainly clarified the law in this area, and that after Sprint, I think courts tend to start right where you are with, does this state proceeding fall within one of the three exceptional categories? But it strikes me that the heart of your argument is less about the nature of the state proceedings and more about the nature of your federal challenge. And your main argument, I think, but tell me if I'm wrong, is that whatever the nature of these state proceedings, the key thing is that our federal claim doesn't intersect with them at all. We're not challenging the judicial process. We're not challenging the outcomes. We're not challenging the proceedings that get these kids into the foster care system. So whatever is going on in state court, it doesn't make any difference because we're not interfering with that. Can we start there?
Yes, Your Honor.
And I'm sorry, that wasn't a rhetorical question. Would you start there? Can we start there as a court?
Yes, Your Honor, I think you can, and I think you must. And in fact, there is nothing that we seek in the federal suit that in any way challenges or interferes what goes on with the state proceedings. They are different proceedings entirely. The state court proceedings are about individual children who have various issues. They are about whether or not a child will be removed. What we're challenging here is the operation of DHHR. The DHHR is the
Well,
agency.
I think you're right in part, right? Your complaint challenges a number of things that just have to do with the operation of DHHR staff, staffing and the availability of placements and things like that. But I think maybe what got the district court concerned is this request for a monitor to be put in place who's going to monitor whether each child actually is placed in the least restrictive, most family-like setting. And that's a requirement under state law that a state judge makes. A state judge decides that. And I think the district court was concerned about putting a federal monitor in place who then is going to double check the state court judge and make sure that those things are happening. Now, we still have to get through the three sprint categories, right? But the district court was concerned, I think, about the breadth of your complaint. It's not just about DHHR.
Right. Thank you, Your Honor. That's exactly the point of this case. We do not in any way challenge anything that's going on in the state court proceedings, nor do we suggest that in order to determine whether DHHR would be violating the law, that the state court decisions would be reviewed. So, in fact, Your Honor, Rule 53 of the Federal Rules of Civil Procedure require that a special master can be appointed. We're not asking for that at this point, but in fact, in other cases similar to this one, almost exact in their descriptions, other state court cases, including in Texas, where the Fifth Circuit upheld the fact that there would be no abstention. Those cases do not look at state court proceedings, do not examine whether or not one child has been appropriately placed, whether the case plan is appropriate. They have focused solely on the administrative agency of the state that is responsible for providing basically if you will, the guts of the system. That is, the state court judges choose among what is available. They don't create what's available. They don't determine that a caseworker has too many caseloads, too many cases. The state DHHR decides what services are available, licenses the services that are available, oversees the services that are available.
Can I ask just a sort of legal theory question, just to get your perspective on it? What do you think is the continuing viability of O'Shea? And that's the case about trying to kind of get around Younger by not interfering in a current proceeding, but requiring state judges to do certain things in future proceedings. What is O'Shea? What's left of O'Shea after Sprint?
I think that O'Shea is still viable. O'Shea was talking about ongoing processes in this criminal court. And the only way that they could really monitor the ongoing processes in the criminal court was by the kind of review that O'Shea found was objectionable. We're not talking about that. And we are talking about a system in which DHHR would provide the resources and the placements and the foster homes and the caseworkers that the judges in the state court proceeding would be able to benefit from as they chose individual places for the child. We are not ever talking about the review of state court decisions either now or in the past. Yes, sir.
Can I ask you a question? And it's picking up on Judge Rushing's earlier question about the request for injunctive relief. What if I thought, just hypothetically, that a few, but only a few, of the requests for injunctive relief related to the references to placements, right? You would require that the agency ensure that certain placements were either the most integrated setting or the least restrictive setting. What if I thought that those could be construed as requiring federal court review of state court placement approvals? Would the appropriate response then be to dismiss the whole case on abstention grounds, to dismiss part of it, to instruct the district court, like this case goes forward, but be careful when you write the injunction, not to write it that way? What should we do if we think there's some ambiguity in a few of the injunctive requests?
Your Honor, I think one of the important factors that a district court has to take into consideration is what kind of relief to provide. And in fact, in a few cases, some of the relief that has been requested, and we don't think we have requested any relief that is impermissible, but some of the relief that has been requested has not been allowed. But in order to make that determination, ultimately, the court has to look at the details of the relief. And so, for example, we think that the district court listed a parade of horribles, essentially, and said, well, this will really interfere because even if you're not directly directing the injunction against the state court judge is going to think, oh, this isn't the right, maybe somebody's going to say this isn't the right placement for a child. That's not the way this case works. This case was decided, of course, on a motion to dismiss. I think all of those concerns that the court is expressing, obviously legitimate concerns, are things that will be brought out as we go forward, if we are allowed to go forward. And I think it would be very clear to the district court what's permissible and what might not be permissible if we seek anything that's not permissible. In other circumstances, in other cases that have refused to abstain, that has been done. I think it certainly could be done here because we are at essentially a preliminary stage of the case. Because all the discovery hasn't been completed, we can't be clear about exactly what relief will be necessary.
Ms. Lowry, let me ask you a little bit about mootness. Since the district court's decision, 2 more named plaintiffs have aged out of foster care, and one of them, Jonathan R., is the last remaining representative of the kinship subclass. If we were to agree with the district court that exceptions to mootness do not apply, would you be able to substitute another named plaintiff to represent the subclass?
Yes, Your Honor, we would be able to substitute necessary plaintiffs.
I take it that you endorse the relate back.
We do.
Theory.
Yes, Your Honor, we do believe relation back applies here, particularly because the district court below had the class certification motion for 8 months and did not decide it. But were the court not to accept that position, not to accept our position on that, we would add new plaintiffs to adequately represent the class and the subclasses.
One other question on a different subject matter. Do you know of any cases beside Judas and Pennzoil where the Supreme Court has approved abstention under the younger third category, that is to regular operation of state judicial system? Are you aware of any other cases?
Are there any cases in which the court has approved abstention under that category?
Yes.
Not that I'm aware of, Your Honor.
Can I ask one clarifying question on the mootness about the two additional plaintiffs who the state said have aged out while it's on appeal? I didn't see it in your reply brief, so I just want to get a confirmation. Do you agree that they have aged out as a factual matter?
Your Honor, the facts are the facts.
Yeah,
yes.
I just wanted to confirm. We don't want to go on just one side's presentation.
Understood, Your Honor, understood. Okay. One of the young people is 18, but is still in DHHR custody. And so I believe that defendants have not moved against that youngster, but we would be able to substitute live plaintiffs, because this is frankly a very serious ongoing problem in the state of West Virginia, the fact that there are serious problems in the foster care system. And so we would have no difficulty finding plaintiffs.
Can I ask you a question about the mootness issue? Because I think I must be missing something, because there's a lot of briefing about mootness, but I'm not sure I understand why it matters if some of the named plaintiffs, but not all of them, have kind of mooted out of the class, given that you can amend and add new class members. Why does it matter?
Well, Your Honor, we want to be sufficiently representative, and we also have subclasses.
Right.
And
but given that you can, I thought your answers to the other questions indicated, and this makes sense to me, that you can always amend or supplement your complaint to add new representatives.
Yes, that's right.
So I guess I'm not understanding, given that this case is going forward regardless, why does it matter whether, there's a whole argument that even when kids age out, that the exceptions to the mootness doctrine ought to apply, but I don't understand what's at stake. And I'm hoping you can just tell me practically why that matters.
Your Honor, I'm not sure that it does.
Okay.
Not sure that it does. I think that this is a very live controversy in the state of West Virginia and a very live issue going forward. And it needs, we believe, it needs to be dealt with as we, so I will go on with my argument then. Yep.
I think your time is
Oh,
up,
so-
but you
oh, I'm
do
sorry.
have time reserved for rebuttal, so. we will-
Okay, thank you, Your Honor. I was looking for the clock and I didn't see it. Thank you very much.
Fine. Mr., is it Pete?
Thank you. May it please the court, Philip Peisch for appellees, which are various state officials and agencies of the state of West Virginia. At the outset, I'd like to address an issue that plaintiffs raised that amici raised in their briefs about the implications of this particular abstention dispute. This case is not about whether foster children can ever bring federal claims in federal courts. There are certainly circumstances where foster children can bring such claims. Abstention would not stand in the way of any claims that focused on executive action, for example. But that is not this case. In this case, the plaintiffs filed a complaint with no consideration for the role that the West Virginia Circuit Courts play in the West Virginia.
Your position is that this complaint does not focus on executive action?
Yes, Your Honor, especially when you look at the relief in paragraph 405. The complaint's about 100 pages long. There is substantial criticism of the executive agency in the complaint. But if you actually look at the claims themselves and what they allege violate federal law and the relief they request, the 4 pages of injunctive relief in paragraph 405, the overwhelming majority is about issues and decisions that are the responsibility of the West Virginia Circuit Courts. And it's not just West Virginia Circuit Courts approving recommendations or reviewing decisions. West Virginia Circuit Courts actually issue orders and are the ultimate entity responsible for those decisions. And I would also add, it's not just placements that West Virginia Circuit Courts are responsible. West Virginia Circuit Courts, they are responsible for approving all placements, which includes a best interest determination and a determination that they're the least restrictive setting.
This case is talking about systemic relief. You submitted one instance where a state circuit judge issued an order that gave relief to that child, but it doesn't, of the nature that they're seeking. Are there any other orders out there other than that one order?
Yes, Your Honor. I believe we actually cited several cases where systemic relief was ordered. So, for example,
a number?
Yes, a number. I think we cited 4 or 5, but I can.
Is that enough to solve the systemic problem in West Virginia?
Well, I would contend, Your Honor, that just because there's been 4 or 5 cases that have addressed, that we cited, that have addressed systemic issues in West Virginia, I don't believe that goes to the key question, which is whether the plaintiffs have an adequate opportunity to raise their claims in state court, and they certainly do.
Well, I mean, the point I was trying to make to you is that if there are a lot of these systemic orders out there, that's one thing if we're talking about younger extension. But if there's only 1 or 2, it looks to me like West Virginia's not doing much about their problem up there.
Your Honor, I strongly disagree with that characterization. The West Virginia Supreme Court, nearly 20% of its docket is now abuse and neglect cases. Nearly 20% of the circuit court docket is abuse and neglect cases. The West Virginia.
So just to be clear, 20% is individual.
Correct, individual. The Supreme Court of Appeals also has a robust court improvement program through which it trains both guardian ad litems, who are lawyers, and circuit courts. I could sort of go on and on about the efforts that the state of West Virginia has made to improve the child welfare system, both the courts and the agency. As the court is likely aware, the West Virginia child welfare system has exploded in population over the last several years. Has increased by 60%, and that's a very tragic and unfortunate situation. But the state of West Virginia, the executive agency, the legislature, the courts have all worked diligently and together to resolve, to improve the system and to address that explosion in the child welfare program. And it's not perfect, and there's many challenges, but involving a federal court to add another layer of oversight on top of that process would not be a productive solution here. But
counsel, particularly after Sprint, we very much contemplate that there may be overlapping and parallel state and federal proceedings. That is the norm. There's nothing wrong with that unless you fall within one of these three exceptional, unless there's interference and unless you also fall within one of these categories. And I wanted to talk to you about the categories because you emphasize in your brief the criminal or quasi-criminal nature of the juvenile delinquency side of these proceedings. I want to bracket whether that's a fair characterization. But in the district court, as I understand it, you argue that those cases are not part of this case at all. They're not part of the class. They're not in front of the court. And the district court didn't resolve that issue. It left that open and it said, I'm just going to focus on the abuse and neglect side. So how can we, given that that is a question in dispute on which the district court hasn't ruled, I don't see how we can kind of assume that those cases are part of this case.
Well, Your Honor, I think they may not be part of this case.
Okay.
As an initial matter, the class definition includes children who are in DHHR custody.
I know, but there was this big fight. I don't fully understand the argument below, but I do understand that the district court thought it was hard enough that it was just not going to reach.
And I understand.
We don't know whether the juvenile delinquency side of things is before us today, right?
Yes, Your Honor. And
Okay.
I think there are no named plaintiffs who came into custody through juvenile justice proceedings if the moot other than the named plaintiff who has been
For
mooted.
today's purposes, you need to persuade us that the abuse and neglect side of things is criminal or quasi-criminal.
Yes, that's correct,
Okay.
Your Honor. Or I would also contend that they are also potentially in the third category of cases. And I would add that, going to Judge Rushing's question at the outset, O'Shea has not been limited by Sprint. And we think that even if Younger doesn't.
The court was really clear. They said these three categories and quote, no further. I mean, they're limiting us to these three categories. Now, they didn't overrule any precedent. They didn't overrule O'Shea, but does that limit O'Shea to the three categories, right? To criminal case, state criminal cases, quasi-criminal, or this sort of interference with, essential judicial, enforcement of its orders. Does it limit O'Shea to those categories?
No, I don't believe it does. I believe O'Shea is still, now with the caveat that the Supreme Court has also said these categories are not rigid pigeonholes, I believe is the phrasing that the court has used. We believe O'Shea is a different but related doctrine that can lead a court to abstain where the ongoing interference with state court proceedings would be so substantial that it would require regular interruptions of state court proceedings.
With any state court proceeding, not just the three categories.
Well, I think there needs to be an important state interest in it, but I don't think it's limited by the three categories. I don't think the Supreme Court has held that.
But O'Shea was a criminal case.
O'Shea was a criminal case, but there have been several circuits that have extended O'Shea to civil cases. And I don't believe this court has, but we think it would be appropriate in this case to hold.
This is a genuine question. I can't remember. Is O'Shea the one where they literally sued the state judges and magistrates? They were defendants about their bail practices and.
Yes, that is the one. They sued a lot of people, including the people yes, it was.
Interference was about as direct.
Interference was about as direct. But I would also add, though, that all these questions go to an important question in this case, which I think is the plaintiff's position is that Younger, O'Shea, abstention never applies in abuse and neglect proceedings. Because it doesn't fit into the three categories, it never applies. If that's the case, that means a plaintiff could file a federal action that directly, or the injunctive relief actually directly states, we are seeking an injunction to prohibit a state court judge from removing children from biological families. And Younger would play no role. That is not the law, and that's directly contrary to Moore versus Sims. Moore versus Sims made clear there are at least certain circumstances where abstention is appropriate in abuse and neglect proceedings. Moore versus Sims has never been overruled. It was cited favorably in both NOPSI and
Moore versus Sims seems really different to me because that really was the state sanctioning the abuse of parents by taking away the children, and then the parents go into federal court to try to stop that state proceeding. And so it seems different both in the kind of interference we're talking about, but also in the, you know, the sanctioning nature of the proceedings. Like they were getting those parents in trouble. They weren't going to go to jail, but they were going to lose custody of their children.
Your Honor, there are some different features of Moore versus Sims,
but I think I guess what I'm getting at is that the different feature goes directly to whether it's quasi-criminal or not.
Your Honor, but 3 of the plaintiffs in Moore versus Sims were the children, and they certainly weren't being sanctioned. And the Supreme Court still—
People were being sanctioned in that proceeding. It was the parents.
In these circuit court proceedings, people are being sanctioned. There's a unitary abuse and neglect proceeding where the abuse and neglect decision is being made. That's a sanction where the parental termination decision is being made. That hearing that makes those decisions, as well as the decisions about what services the child should receive, if the child is removed from the home, what placement, those are all single proceedings before a single court. It's a single proceeding. So I would contend that there are sanctions going on in these proceedings. And in Moore versus Sims, there was relief sought that didn't directly implicate this.
Can I ask you about that? When I know that the court is involved in the initial placement of the children, but that's all kind of precedes the part where they are in state custody, which is what the plaintiffs are suing about. That part of the proceeding doesn't seem to be ongoing. Do you know what I'm saying? Like, isn't that sort of kind of history at this point?
So I'm not sure I follow the question, but I think I disagree with the characterization. So oftentimes a child is not removed from the home until a circuit court issues that order. The only time a child can be removed from a home is when unless there's an emergency issue and there's like a 48-hour rule. But then the child is removed on a finding of endangerment, and then the circuit court retains jurisdiction and has.
But are there any proceedings after that point, the ongoing proceedings? Are there any of those that would be fair to describe as sanctions? At that point, aren't we just talking about the best interest of the child? No one's getting in trouble. They're just trying to do what's right for the children.
So I would say if after parental termination, there may be no longer a sanction going on.
Ongoing proceedings don't have anything to do with sanctioning.
I would disagree with that again, because oftentimes parental termination, there's many children in the West Virginia foster care system whose parental rights are never terminated. And they're in hearings for year, 2 years. That's on the longer end, but there's a service plan going on for the parent. The parent's trying to earn their right to come back. They're providing services to the child. So now some of the named plaintiffs in this case, the parental termination wasn't even contested. So that piece ended early, but there's many cases where that piece goes on for a year or two, and never ends until the child is returned to the family. And reunification is still the primary goal in this case. So most, well, I don't know if I can say most, but a large number of foster children in West Virginia are reunified with their family. And in that case, the sanction-ish part of the hearing never ends. It's never ended. The turning back to some of the interference issues, as I mentioned earlier, I think paragraph 405 of the complaint, where the plaintiffs seek injunctive relief, in our view, the overwhelming majority of that relief would interfere with ongoing circuit court proceedings. Although much of the allegations in the complaint, before you get to the actual description of the claims and the relief, are critical of DHHR and the governor, when you look at the actual relief the plaintiffs seek, it directly interferes with ongoing circuit court proceedings. So we've already talked about placements. They seek a number of requirements for children's placements. They also seek an injunction that all children's case plans be adequate and individualized. Well, circuit courts are responsible for reviewing children's case plans, and they review those case plans and approve them every 90 days. Plaintiffs also seek an injunction that all children must timely receive services and treatment set out in their case plans. Again, circuit courts review those, and they make decisions on them every 90 days. And in fact, there's cases we've cited in our brief where the circuit court holds DHHR in contempt if DHHR doesn't comply with the case plan. All children must receive services to the extent required by, quote, reasonable professional standards. Again, those are decisions being made by the circuit courts in these cases. It's impossible to see how the overwhelming majority of that relief would do anything other than interfere with those proceedings. I think this is highlighted if you actually look at a named plaintiff's case.
Can I just, I just want to make sure I understand your position. So your view is that the overwhelming majority of the sort of specific injunctive requests would interfere. What if, just hypothetically, like 1/20th of them might interfere? Same result? Like, does it matter to you that it's the overwhelming majority, or would just one require that we dismiss the whole action?
I think it does matter, Your Honor. And frankly, that's something we've wrestled with internally and discussed extensively. I think it would be one thing. I think the extent of it would be one thing if there was one claim that interfered or one piece of relief that interfered. I think in that case, it might be appropriate for a district court to dismiss that one claim. But in a case like this, where there's 4 pages of paragraphs of injunctive relief, and the overwhelming majority would interfere, and there's no indication that the complaint took any consideration for the role that the circuit courts play in the state of West Virginia, I don't think it's reasonable to expect the district court to sort of rewrite the complaint and wade through those 4 pages and say this paragraph stays, that paragraph doesn't, I would also add that until oral argument here, the plaintiffs have never raised that argument in their briefs. Nowhere in their briefs do they even mention, let alone quote or anything in paragraph 405 of their complaint or explain why it doesn't interfere. So I think there's an issue as to whether they've properly raised a sort of partial abstention issue at all. But also, I'm not sure that's the relief they even want. I'm not sure the plaintiffs are interested in some of the relief surviving. It's always been our understanding that the only relief that the plaintiffs are interested in this case is sort of wholesale relief that applies across the board to West Virginia.
That's so weird. I mean, just looking at the complaint, it seems to me, and the request for injunctive relief, that they would be very interested in things like staffing levels and things like training for kinship placements. I mean, there's a lot of this case that has literally nothing to do with what happens in court.
So, Your Honor, I disagree with that. That has literally nothing to do with what happens in court. Let's take kinship training, for example. Now, there may be requiring DHHR to offer kinship training, which, by the way, it already does. That's not the relief requested in here. It's requiring that all kinship settings receive that training. That's a major problem because a lot of children are placed in kinship homes that are the appropriate placement for them, but the parents, they're not foster parents. They've had kids, they don't want to go through kinship training. And circuit courts order that you be placed with your uncle who you have a pre-existing relationship with, regardless of whether your uncle takes that kinship training or not. And that West Virginia offers financial incentives for kinship homes to become certified and go through that training, and many, many homes decline to do it. And West Virginia, so requiring kinship placements to accept training does interfere with ongoing circuit court proceedings because it would prohibit a circuit court from ordering a child to his or her uncle's house if the uncle refused to engage in the training. With respect to caseworkers, again, I think it's on the less interference side, but circuit courts in West Virginia have ordered caseworkers off cases when they don't think they're appropriate. They've replaced caseworkers. In one case we cite in our brief, they replaced in the 90s, they replaced DHHR with an independent agency caseworker. If a federal court were to impose a 15 case limit and a caseworker reached that limit, DHHR would have to take that caseworker off one of the 15 cases. And put aside that would require hundreds of more caseworkers that we can't hire, but and the circuit court might have something to say about that, about whether that caseworker who's been with the child for 6 months or a year should be taken off the case. I say all this, this is an extraordinarily intertwined system. What DHHR in the state of West Virginia, what DHHR does and what the circuit courts do is, and you can look at the statute, you can look at the judicial bench book, which is you may not want to look at the judicial bench book. It's like 800 pages, but it is very hard to separate those two and the working relationship between DHHR and the circuit courts. And it's very hard to issue injunctive relief that wouldn't interfere with circuit court proceedings. Now, I could come up with a couple that I think might, and I think there's a couple pieces of their relief that doesn't interfere. But I think a lot of their relief that looks like it doesn't interfere would in fact interfere. I see I only have a few seconds remaining. I haven't talked about the mootness issue. With respect to mootness, we're prepared to believe those are straightforward issues, and we're prepared to rest on our briefs on those. I guess in conclusion, we would urge the court to affirm. We think the district court did not abuse its discretion in abstaining in this case, given the extent to which the plaintiff's claims and the requested relief would interfere with ongoing circuit court proceedings, and the state's substantial and important interest in proceedings that involve children in their custody, and the opportunities that plaintiffs had to bring these claims in state court. I have no more.
Thank you.
Your Honor, in filing this complaint and proceeding with this case, we do not in any way want to suggest that the circuit courts are not doing their due diligence and fulfilling their responsibilities. The circuit courts have limitations on what they can do. They do not control what DHHR provides. The legislature can pass statutes and the state can issue policies, many of which are absolutely fine. But if DHHR does not implement those policies and doesn't implement the statutes, then the children are left with a system that is seriously and unconstitutionally inadequate. They are separate systems. We do not criticize a circuit court judge for any decision. We do not want to examine those decisions. But DHHR is substantially failing to protect the constitutional rights of children after they are in the department's custody. These children, whether they are children who are abuse neglect children, or whether they are delinquency children who have been placed with the commissioner of HR, those are children who are subject to the provisions that DHHR has made with regard to placements, with regard to kinship homes, with regard to the supervision of homes, with regard to every aspect of what happens to these children once they are in custody. And that is what we are complaining about. And in fact, if you look at what we asked for in relief in paragraph 405, as my colleague references, most of these, if not all of these things, we would argue, and I think it's true, that all of these things are things that DHHR only has the control over. There have been a few cases where a circuit court judge has noticed that the caseloads are too high. It wasn't a complaint raised by a child. Mr. Peisch talks about the fact that the children can represent their interests in the court. They cannot. The parents can represent their interests. Nothing wrong with that, of course. But by Mr. Peisch's reasoning, the children in custody in the state of West Virginia would not have the right to bring a suit. If DHHR had they have 6,000 children in custody, supposing they had only 100 caseworkers, DHHR would not be able to complain, would not be held accountable for that under Mr. Peisch's reasoning. So what we are complaining about is the fact that there are two systems. Circuit court is doing its job as best it can with what exists in the system, and the DHHR is not providing what the system needs. They are systemic claims. The DHHR needs more placements. It needs more caseworkers. It needs better systems. It needs to train people better. All of those things are not dealt with at a systemic level by the circuit court. The cases that Mr. Peisch refers to of systemic decisions by the circuit court are not brought by children and are very few, if any. Most of the cases cited by Mr. Peisch, most of which were unpublished, are cases in which children with either custody cases or cases having to do with parental right issues. Parents have an absolute right to raise those issues, of course. That's not what this case is about.
Can you respond to, he said, your friend on the other side said, if we accept your reading of Sprint in the 3 categories and say that this case doesn't fall into one of those categories, then a plaintiff could file a lawsuit seeking to enjoin a state court judge from placing that child in a particular placement, because we've said these state court proceedings don't qualify under any of the Sprint categories. Can you respond to that?
Yes, Your Honor, that would be wrong. I don't think that would be at all possible, and that's not the kind of decision we're looking for from the court. We are talking about serious systemic problems that exist in the foster care system as a result of DHHR not being able to, or whatever else is going on, provide the services and placements kids need.
Which category would that case, hypothetical case, which Sprint category would that fall in?
It might fall into the quasi-criminal proceeding. It might fall under Rooker-Feldman if a circuit court has placed.
It can't be Rooker-Feldman because there's been no judgment. It's seeking to enjoin a future action. And then it's not quasi-criminal because we've already talked about how proceedings against the child aren't quasi-criminal. It's if a child seeks to enjoin placement in a particular home, that's not an action against the child.
Your Honor, I would suggest that the proceedings are not quasi-criminal as they relate to children. They are quasi-criminal solely as they relate to parents.
Right.
They are not. So a child who wanted to enjoin a state court proceeding placing the child in a home, I think would have a Rooker-Feldman issue. That is, there would be a state court decision and the child would ask a federal court to review a state court decision. I think there would be no basis to do that. I think that has to go through the state court system.
I'll let you move on, but that's not Rooker-Feldman, right? Rooker-Feldman says you have a judgment that has injured you and you're suing in state court because of the injury caused by that judgment, not that you're suing to enjoin future action. So We're still kind of stuck with, how does the federal court say, oh, it's not my place to enjoin the state court from making this certain family law decision?
Right, Your Honor, I think that is frankly, I think a preposterous suggestion, if you'll forgive me for saying that, by Mr. Peisch. I think that children would not have any basis to challenge a particular placement except through the state court system. It is not a quasi-criminal proceeding against a child, and I don't think that would be possible. And if they were going to do that, I would think that would not get very far. But I think that a child who is challenging an individual placement would not have the basis to do that. Your Honor, I think that what the court does here is extremely important to the children of West Virginia. And I think that the situation in West Virginia is a situation that raises very, very serious problems. I think that this case does not fall into any of the Sprint categories. I think there was inappropriate abstention by the district court expanding Sprint far beyond what was contemplated by Sprint. And I think that it is impermissible and objectionable, and it should be reversed by this court. That would be what we would want to conclude with here, and we urge the court to consider that seriously. Thank you very much.
Thank you very much. Thank you both. We are sorry that we can't come down and shake hands with you as would be our custom, but we very much appreciate your help today. Thank you. Can hear argument now in our third and fourth cases, numbers 21-1079 Eden versus Justice and 21-1102 AJA Enterprise versus Justice. And I believe we're starting with Mr. Sheehan. Is that right?
Yes, Your Honor.
Thank you.
Your Honor, I represented AJE below and the rest of those defendants, plaintiffs. We refer to them as the Monongalia County Bar Association members for convenience. The government exists to advance the public good. Sometimes public good requires difficult choices to be made. Best example is when there's a forest fire. Sometimes we set fire ahead of it to deprive the fire of fuel. And sometimes we'll burn down someone's house. That's fine. But the function of government then is to distribute that loss of that individual who suffered across a larger spectrum. So here, that has not occurred. What happened here with pandemic issues is that Governor Justice imposed a variety of executive orders that have specifically impacted the bar owners in Morgan and in Monongalia County and in the city of Morgantown. In West Virginia, like other places, we have planned for emergencies. We have an emergency statute, but the governor made an effort to impose himself on a public health system. We, in fact, also have legislation that deals with public health fully and completely. Those jobs.
And I understand that practically every state has a state of emergency statute. My question is the state of emergency still in effect?
My understanding is it is, Your Honor. And so this, I have looked at some mootness cases, in fact, one from this court and other places, those have disappeared. And so that rule changes.
Counsel, I'm sorry, what is your argument for why this case is not moot?
Oh, well, I've asked for a couple of things, Judge. Most importantly, the Supreme Court has said that as long as we're under an existing threat, I think that the mootness is not an issue. And because there are still a state of emergency, then that's a problem for us. Number two, one of the things that we asked for in our complaint is we asked for this, for the court to require the state to initiate condemnation proceedings. So basically, we've described that as a reverse condemnation issue. And because that would deal with constitutional issues, we think that that's appropriate to be handled by the court. Now, it is true that the district court could not award me damages under 11th Amendment principles. And so we didn't ask for that. So what we asked for is this reverse condemnation process to go forward. And that's referred to, I think, on pages 31 and 32
Is
of the
that the
appendix.
same? I know you had a takings claim and a reverse condemnation claim. Are those one and the same, or are they separate claims with separate theories? I was a little unclear.
Judge, it's a little difficult. We've just, in 2017, West Virginia described reverse condemnation as applying to personal property. I think that it invigorates the takings claim. If the district court can't get to it, then it'll set up another process. If the district court can't get to it because of 11th Amendment issues, then this sets up a process for the court to have a way of addressing the harm, but not awarding the damages, and then will allow me to proceed further with the damage issue, assuming that I can make the takings case.
Could that claim be brought against the city or only against the state?
Well, I think I can do it either way. I think I can do both. Traditionally, it's only the state that enjoys 11th Amendment immunity.
Right, you could get damages from the city, but I didn't know if they actually are on the hook for takings or if it's only the state. I really just don't know.
I think it's to be determined, Judge. The takings issue is a difficult one for me. I have relied primarily on the Sawyer case from when the president took the steel mills, and the difficulties there is that court said that there were takings problems, and I acknowledge that there remain some issues under the takings jurisprudence, but those seem to be evaporate, I won't say evaporating, that's too far a word, but they are lessening over time. The issue at one time had been that you could only have a takings case if the government took 100% of what you owned. And we have seen the government take less than 100% and still have takings awarded. There's a case in the Supreme Court about air rights in New York that I would indicate. So I think that's a curable problem. Yes, Your Honor. Sorry.
I'm sorry.
Oh, sorry.
No, you go ahead. Judge.
I just wanted to clarify in the looking at your briefs in the district court on, I guess, on the preliminary injunction, because I know that there wasn't an opposition to the motion to dismiss, but you addressed the takings claim, but I didn't see reverse condemnation mentioned in any of the district court filings. And so I was a little confused about whether that had been forfeited or whether that is somehow incorporated in the takings label.
Judge, I was trying to pursue a preliminary injunction at that point in time, and I don't think that I've given up other items that I outlined in the complaint when I did that as well.
But you didn't oppose the motion to dismiss on any ground.
I did not file a brief. I did mechanically, Judge, to explain what happened. My brief was due here on the preliminary injunction issue, and I intended to rewrite it and file it with Judge Bailey. I missed the deadline, and he ruled very promptly. He's a good district court judge, and he did exactly what he should do. And so consequently, I was late. So I felt I'd made the arguments, and that's why I don't think that I lose on a procedural nicety for having failed to file that brief.
Can I ask you about a different procedural nicety? I don't see a takings argument. Your brief on appeal seems only to raise the issue of separation of powers and how the governor violated West Virginia's separation of powers, and then sort of acknowledging that that's not usually something a federal court can address, and then that in turn violated the federal due process clause. But I don't see any other argument in your brief on appeal.
Well, I'll agree with you, Judge. But if there is a due process problem, then I'm entitled to the remedies to go with it. And I think the takings part of that is part of that due process issue.
Okay, but we agree that the only argument in your brief on appeal is the separation of powers due process argument.
Yes, Your Honor.
Okay.
As I said, I think our public health statutes were full and robust. When I asked the director of public health in Morgantown, both an experienced physician and a graduate of law school, in fact, a member of the bar, he indicated that nothing that the governor had ordered as part of these executive orders gave him authority that he needed and did not have. And so that turns out to me to be a very telling problem here. The governor really has no role in public health. The public health director was going to deal with it. We're going to deal with it in the traditional way, which is to isolate people who are ill, isolate people who've been exposed to people who've been ill, and ultimately, much like a forest fire, to let it burn out, even if we don't have a cure. Now, we've not necessarily gotten a cure, but we've gotten a lot more weapons since this case was filed. But that's where we are. So I feel that the governor has gone a little. If I'm over time, I'll stop. But
you can finish your sentence.
But I really feel the governor went too far, and that's what the due process issue is here. Thank you, Your Honor.
Mr. Harris, before you get started, there is this little pesky issue called jurisdiction. I see that it doesn't look like that you're guaranteeing those claims.
We are, Judge Floyd. 9, we fully recognize and accept the concept that federal courts must afford substantial deference to state and local officials during time of crisis or emergency. But the idea of crisis or emergency gives rise to something that is finite, that's brief in its duration. And as Judge Floyd asked the question, we have been in a state of emergency in West Virginia for almost 2 years with no end in sight. There has been no media or reference by the governor saying we're going to end emergency powers like, for example, the Commonwealth of Virginia has. There has been none of that. It
has been almost a year since any of the executive orders that are on issue in this appeal. Almost a year ago, they were all terminated and no new restrictions have been put in place.
Respectfully, Judge Rushing, they haven't been terminated. There were new executive orders placed in effect, you're correct, Your Honor, about a year ago. Those remain in effect.
So just to make sure we're all talking about the same thing, I'm talking about Executive Order 1221, which expressly terminates all of the others that are on appeal here.
As I understand it, Judge Rushing, not to argue with you, but the executive order that still puts in place the 100-person limit for outside gatherings is still in place.
That's 821, and I think 821 is included in those that are terminated by 1221, right? I mean, I may be wrong. That's why I'm asking. We got to talk about the details here because the details matter.
We do, Judge Rushing. And it was my understanding that in the governor's brief, he makes the argument that these issues have now been resolved. For example, issues of visiting restaurants and bars are now back to normal 100% capacity. But if you look at the language of those executive orders, that isn't correct. The way it's structured is, first of all, we are still in a state of emergency, which gives the governor the power to do what he has been doing for the past 2 years.
We just held in Lighthouse that the fact that the governor or the government has authority to do something again isn't enough to show that it is likely to recur. So we're going to need more than the authority to act.
That's right, Judge Harris. But in the Lighthouse case, the governor of the Commonwealth of Virginia had essentially given up his emergency powers.
All I'm saying is that we also held in that case that the authority to act does not by itself show the sort of reasonable likelihood of recurrence we're looking for. But that's when we're talking about voluntary cessation. It seems like you're saying this case isn't moot at all because these orders actually haven't been rescinded.
Yeah, the thrust, Judge Harris, of my argument is we have great concern on the First Amendment issue regarding public gatherings. I know in our brief we talked about other issues, but for purposes here today, we have great concern over that. What happened was there were a series of executive orders that started out with a 10-person limit, then a 5-person limit per color coding of counties, then going from a 75-person limit to a 100-person limit. And right now, as it stands, as I understand it, and counsel for the governor can correct me, I may be mistaken. As I understand it, the 100-person limit for public gatherings imposed by the governor's executive order is still in place.
Can I just ask you a question about your First Amendment, the right to assemble claim? I didn't see any allegations in the complaint that any of the plaintiffs want to assemble in a group of more than 100. And I don't see why there would be third party standing in this case to raise somebody else's right to assemble in a group of 100.
Judge Harris, you're absolutely correct. In count 6 of the First Amendment complaint, we pled these First Amendment challenges to bring the issue to the district court. This issue of standing with a proper pleading was never raised by the governor, nor
jurisdictional.
But I would say this court has the ability to take a look at the executive orders under the circumstances and determine whether or not they're facially invalid. And we take the position they are. And the governor, I think in his brief, talks in terms of this concept of intermediate scrutiny. And he cites the speech case Ross versus Early that came down from the Fourth Circuit. If that's the case, if the governor concedes that the executive order related to these public gathering limitations is subject to intermediate scrutiny, then when you look at that, it seems to me the district court should have given us the opportunity to have witnesses cross-examine. Every executive order from the governor says we're relying on public health officials. Nowhere in the order does it specify what the public officials say. And so we take the position that we should have had the opportunity to cross-examine the health officials that the governor is relying upon to say it's more harmful to have 100 people at a public gathering as opposed to 75 people or 500 people. Our point is those numbers to us appear to be arbitrary. And so if it's going to be subject, this concept of intermediate scrutiny with regard to these public gatherings, then we think the case should be reversed. We should have discovery and an evidentiary hearing with regard to the expert opinions and why the public health officials, per the governor, say it's not safe to have 50 people, or it's safe to have 75, or it's safe to have 100. It just seems to us those numbers are arbitrary. And so we ask the court to reverse the district court and send the case back for further discovery. Thank you.
Good afternoon, Your Honors, Judge Harris. It's great to see you all. I'm Ben Hogan. From the law firm of Bailey and Glasser, and I represent the governor and Commissioner Wooten in these consolidated appeals. The last time I had the pleasure of appearing before the court, I was in my dining room. And it's great to see you. It's great to be here, back for in-person arguments. And I think it's fair to say that we're in a vastly different place than we were 2 years ago. And of course, like nearly every state in the country, Governor Justice imposed a state of emergency in March 2020. And the orders were focused on protecting the public health, and we knew very little about this disease. We're no longer sewing masks for our neighbors to preserve PPE for our frontline workers. We're no longer limiting who can go to restaurants and bars in West Virginia.
On that point, just to kind of cut to my question for your friend on the other side, this 100-person limit, they point to Executive Order 8-21 and 9-20. I'm reading Executive Order 12-21, and both of those are expressly listed here as executive orders that are terminated. Is that, number one, am I reading that correctly? And number two, does the result of that mean the 100-person limit is no longer in place in West Virginia?
Yes, Your Honor, you're reading that correctly.
Has there been another limit put in place on the number of people who can gather?
No, Your Honor, there is not. The only executive orders that remain actually suspend a number of regulatory requirements for businesses like bars and restaurants. And they, in fact, allow the businesses like bars and restaurants to continue to do what they did early in the pandemic. And that is, for example, sell wine and beer to go, which was previously prohibited. It relaxes licensure fees and requirements for those entities. And so as a result, although there is still a state of an emergency in West Virginia, it's a distinction without a difference with respect to the Lighthouse case, which is on all fours here. And quite frankly, we have had the tincture of time to answer the voluntary cessation question. The executive orders expired in April 19, 2021. Since then, the mask mandate was also lifted in West Virginia. Since then, we have had the two most infectious waves of disease with respect to the coronavirus, the Delta variant and the Omicron variant. And as a result of neither of those variants, were there any restrictions reimposed in response to those? And that's something that the courts grappled with in the cases we submitted in our 28J letter.
Well, is that direct evidence or indirect evidence that there's not the likelihood of repetition?
There's the direct evidence, Your Honor, is I believe information that the court can take by judicial notice, and that is the scope of the Omicron and Delta waves, the fact that the executive orders, which the court can take judicial notice of, have not been reimposed, and that there's been no whiff of opportunism, as Judge Wilkinson said in the American Federation case, that these executive orders were ended as a result of this litigation. They have no bearing or relation to the litigation.
Why is there still a state of emergency? I'm just curious. Are there plans to terminate it? Was there some benchmark when it will be terminated?
Judge Harris, I'm not sure exactly what the governor's plans are there, but I can say that part of the reason I believe that there is a state of emergency is because there are a host of executive orders that do suspend a number of regulatory regimes that, quite frankly, make it easier for businesses and others to operate. There are also some provisions in the still existing executive orders that have to do with allowing public employees to use the time off that they didn't get to use during the pandemic because they were, say, frontline workers. There are still provisions in place for the hospitals and making sure that they're required to have a plan in place to provide enough PPE and in the event of a surge and, like we've seen in the past where the hospitals have been overwhelmed. And, as the Supreme Court said in the Hodel v. Vance case, during an emergency, summary disposition and administration is understandable, and it's not hard to grasp why. And that's exactly what occurred here in the early times, right? But here we are, and there's no live case or controversy, quite frankly. The orders have been moot, and neither of the exceptions to the mootness doctrine apply. I would like to raise one additional aspect with respect to the AJE case as to why the court need not even reach mootness. All of the claims that are raised on appeal have been waived by the plaintiffs did not respond to the motion to dismiss or the city of Morgantown's motion for summary judgment. After the district court issued its opinion, there was no Rule 59E or Rule 60 motion for post-judgment relief. And there's a case out of the Fourth Circuit that we didn't cite in our brief, but it's the Pomerlau case versus West Springfield. And it's a case that Judge Floyd cited with approval in the Stevenson versus City of Mount Pleasant, which is a 2014 decision. And that case explains, and the 10th Circuit also holds the same, that although the district court has an obligation to review a complaint for viable claims, even in the absence of an opposition brief, when a party fails to respond in opposition and seek any post-judgment relief, those claims are waived on appeal. And the site for that case is 362 F 3rd 143. And it's an unusual factual circumstance and procedural posture. And I think that that's why the Fourth Circuit doesn't have any case that is directly on point factually, but that Pomerlau case is precisely what happened here.
Let's ask you a question about order of operations. So mootness is sort of an Article 3 jurisdictional question. So normally we think, well, we have to do jurisdiction first, but I take it what you're saying is that this waiver ground is just another threshold ground, and we can, as long as we're not ruling on the merits, we can dismiss a case on any threshold ground, even if we don't reach jurisdiction. Is that right?
Correct. And Judge Harris, here's the difference, and here's why it matters. If the court rules that the Eden case is moot, which it is, then under Munsingware, I'll leave this to the court to decide, but it will probably be vacated, the lower court decision. In instances where plaintiffs fail to respond or otherwise object to the judgment of the district court, in each of the cases that I mentioned, including the case out of the 10th Circuit, which is Pickens v. Mike Houghton, and that's 166 F 3rd 1221. In both of those cases where forfeiture occurred, the court affirmed a lower court decision. And so in AJE, the court should both dismiss for waiver and affirm the lower court's decision because those arguments have been forfeited. And so that's why the distinction is not without a difference there. I can briefly, I think, summarize why, if the court does choose to get to the merits of the claims, why each of them fails. And it's for two fundamental reasons. First, in none of the causes of action, even those that were waived, but if you just look at the complaint and take it for what it is, none of the causes of action allege a recognized property right for the takings or the due process claims. They don't allege a recognized liberty interest. They don't allege anything that would get them over that first hurdle in pleading the elements of the claims. And for example, the general right to do business is, and we've briefed this, but the general right to do business is not something that's recognized as a property or a liberty interest. In a takings instance, the Murr versus Wisconsin case explains that it has to be a deprivation of all economically beneficial use of the plaintiff's property. Now, that is not talking about the beneficial use of their chosen business model. It's talking about legal interests in the physical property. And as many people and many businesses did during the pandemic, they pivoted and they changed their business models. Gyms offered online fitness courses. Business restaurants and bars changed the way that they served their customers and patrons. And the U.S. Supreme Court has also made clear that a temporary cessation in the ability to do business as you've done it in the past does not amount to a regulatory taking. The equal protection claims in both complaints fail because there's not an identification of a fundamental right. Again, the interest in doing the general right to do business, nor is there a suspect class identified that would give anything, that would give rise to anything other than a rational basis review. And just to my friend on the other side's point that we conceded that intermediate scrutiny applies to the First Amendment issue. We don't concede that. We argue it in the alternative, just as the district court did. The district court applied rational basis and then said, even if intermediate scrutiny applied, this is content neutral, time, place, and manner restriction that would not violate the First Amendment because it is narrowly tailored and tied to a significant governmental interest, indeed a compelling interest. And the district court even applied strict scrutiny to the First Amendment claim and said that it would still fail given the significant and compelling governmental interest. And with the breach, any claims for separation of powers that AJE, for example, did raise in their brief on appeal, those are barred by Pennhurst to the extent that they're asking the federal courts to apply state law and enforce state law against state actors. So with that, Your Honors, I will turn it over to my friend from Morgantown. I would ask that the district court be that the Eden case be dismissed as moot, and that the AJE case be dismissed for waiver and forfeiture, and that the district court be affirmed in AJE. Thank you.
Thank you, Your Honor. May it please the court. Ryan Simonton with the law firm of K. Casto and Cheney. I'm representing the city of Morgantown and Morgantown City Manager A. Kim Halls. These parties are named as respondents in the appeal filed by AJE Enterprises et al., the Monongalia County bar owners. However, those bar owners do not raise any contentions about Morgantown's actions in their appeal. Because of that, because those claims are not made in the opening brief under Rule 28 and under U.S. versus Alhamdi, the claims are abandoned and the district court opinion should be affirmed. Morgantown gets 2 sentences in the end of the summary of argument in the opening brief, and the basis of the statements is that the governor's orders were incorporated within the city of Morgantown statutes. So no independent claim exists, no claim was raised on appeal, and as to Morgantown, the district court order must stand. This is in addition, of course, to the governor's council's recitation of the waiver of the option to respond based on the failure to respond to the motion to dismiss, which provides a separate basis to affirm the district court's order as to all parties. To the extent that the court would consider the merits and consider them as to the city of Morgantown, AJE and the related parties have failed to state any basis to reverse the district court's opinion. All public health regulations at issue were proper exercises of the police power. As to these bar owners, they're properly analyzed under rational basis tests, and HAE cannot negate every conceivable basis that those are rationally related to the legitimate public purpose of preventing harm during a pandemic. I would welcome any questions from the court, but if there are none, I would cede the remainder of my time. Thank you.
In the ordinary procedural case where there was a motion for summary judgment filed and there was no response, I would concede that matter has been forfeited. What is different about this particular case is that there was a preliminary injunction hearing, there was substantial argument, and I believe that a number of the issues were placed before the court. So I would distinguish that on that particular basis. Whether that's adequate or not, I'll leave for the court to decide. It certainly was not done maliciously, it wasn't done frivolously. If you look at the timing of the orders, you'll see that my representation about my focus on responding to this court on the preliminary injunction matter will be verified. One of my clients purchased a business. It was a dance hall type business. It was in lease space. That business is destroyed. His obligations to pay rent, to make payments for his business continue. His testimony is of record. And so we can talk about a temporary taking, we can talk about a pivot, we can talk about all of that kind of stuff. Reality is that that's not true. If you look at the Sawyer case where the government took steel mills, the Supreme Court says this is a problem. This could be a problem under the takings clause, and that's why emergency action, the fastest action at the Supreme Court, I think, in the history of the Union, occurred from the date that the case is filed in the district court to the decision at the Supreme Court. It's less than 65 days. That case is reversed. This is a substantial undoing of a tremendous hardship. And while I recognize that there is some case law that says you've got to take everything or you've got to destroy a business, the business model doesn't get to go on. Reality is in business, you can't pivot quite that quickly. No one can. There's a harm imposed, and that's the difficulty. I'm going to go over my time just a couple of seconds. I am a bankruptcy trustee, and one of the orders that is amended is that we can take an oath remotely. Historically, you couldn't do that, and so that is an ongoing and beneficial regulatory amendment, and so I'll give that one up. Thank you, Judge.
If I may, here is my analysis with regard to the issues of the orders in place. I do not doubt the representations of counsel for the governor, but this is, as I understand it, the record before us. On 4/13/2021, the governor filed with this court, document 18, 3 additional executive orders. The first one, dated March 8th, 2021, continues to contain the offending language that we say offends the First Amendment. And that's found on page 5 of 15 of that filing and 6 of 15, which talks about the numbers in social gatherings. The third order in document 18 is Executive Order 1021. On the last page of that order, it talks about the governor terminating Section 4 of his Executive Order 9-20. That's found at Joint Appendix 038, that page. Section 4 says prohibited activities, but it has to do with places of public amusement, whether indoors or outdoors, amusement rides, carnivals, zoos, museums. It has nothing to do with gatherings of individuals outside, whether it's 5, 50, 75, or 100. That's found on Section 5, avoid social gatherings, on JA 38. So that's my understanding of the status of the record.
Have you read Executive Order 1221?
If it's in the papers, Your Honor, I have read them.
1221 is the one that terminates the executive orders we're talking about. It terminates 920 and 821 completely.
Okay, Judge, if it's in the papers, I have read it. If it isn't in the papers, I haven't read it.
I'm just asking because you mentioned 1021 and it did leave something in place, but then 1221 came after.
Yeah, then if it's not here, I haven't seen it, Judge. So if that's the case, Your Honor, then what we have left is the mootness issue. And I would say it was distinguishable because we still have a state of emergency. Thank you.
Questions? All right. Well, thank you very much. We are sorry that we can't come down and shake hands as would be our custom, but we do appreciate your help today. Thank you. And we can adjourn for the day.